Well, good morning. Welcome to the latest DMH Stallard Employment Law podcast. I'm delighted that today I'm joined by my colleague Lydia Goodman, and today we're going to be looking at disability discrimination and particularly reasonable adjustments in the workplace. So, Lydia, maybe you could just start us off. How and where does the duty to make reasonable adjustments arise?
So the duty arises from Section 20 and Schedule A of the Equality Act, and that imposes a duty on employers to make reasonable adjustments to help disabled job applicants and disabled employees in certain circumstances. And these typically arise where a disabled person is placed at a substantial disadvantage in the workplace or during the recruitment process by an employer's provision, criterion, or practice, a PCP. It might also be a disadvantage by reason of a physical feature of the employer's premises, or an employee might be disadvantaged by an employer's failure to provide an auxiliary aid. Employers aren't obliged to make reasonable adjustments unless the employer knows or ought reasonably to know that the individual in question is disabled or is likely to be placed at a substantial disadvantage because of their disability. However, the issue of knowledge and consequent topics of what adjustments do we need to make and to what extent that they're reasonable raise a number of questions and issues in HR offices across the UK.
I think it's also fair to say, isn't it, that we've seen an increase in the number of claims relating to neurodivergent individuals and reasonable adjustments. And just to flag that, actually, we're going to do a separate podcast in relation to that, because that's a burgeoning area as well. But Lydia, how do we know who it is we need to make reasonable adjustments for?
It's pretty much a duty for employers to make adjustments for their workers, for their employees, and even for job applicants. And there's a very poignant case on job applications, actually. It's the case of ICOM Limited versus Mallon. And this case addressed the issue of adjustments for applicants. So Mr. Mallon was an applicant. He was disabled by reason of dyspraxia. And in the tribunal, he argued that ICOM's requirement that he use their online form to apply for a job rather than allowing him to apply via email or via telephone put him at a substantial disadvantage. And the Employment Appeal Tribunal held that this duty to make reasonable adjustments extended to a duty to make inquiries of an employee or an applicant, and it was not open for the employer in this case to argue that they hadn't been told of a disability or adjustments specifically. The Appeal Tribunal determined that the employer hadn't made reasonable inquiries of the claimant such that it could decide whether or not these reasonable adjustments needed to be made. And in fact, he may have been more successful in a job application had he been able to apply via telephone or via email, as opposed to just using their online form.
Thank you. One of the biggest questions I think that employers will have is, how do we know if an employee is disabled and or that they're likely to be placed at a substantial disadvantage?
This particular area for employers is quite a tricky question to grapple with. So the duty doesn't apply to an employer if the employer doesn't know and could not reasonably expected to know that the employee or the applicant has a disability. So the starting point in the employment tribunals is that the employer must have actual or constructive knowledge. And actual knowledge is quite easy. You might have an employee that says, I'm disabled, here's my diagnosis, this is the effect it has on my day-to-day life, and this is what I need in terms of reasonable adjustments. And that's sort of usually quite straightforward. However, constructive knowledge is a little bit more tricky. And this requirement for an employer to have constructive knowledge therefore puts the onus onto employers to really understand their employees and take reasonable steps to work out what kind of disadvantage the employee is at and how to remedy this. And we've got the recent decision from the case of Gallup against Newport, in which the tribunal held that the employer has to know the relevant factual matters constituting disability, but it needn't know the statutory test for disability. So it's important to note that a formal diagnosis of disability is not determinative. And we do, Rustum, as you've already alluded to, we've been seeing a big increase in claims around neurodivergent conditions. But of course, we've got very long wait lists to get a diagnostic report. So we're often confronted with self-diagnosis in those situations. Um, and because of this, knowledge is therefore very much a factual matter. The employer doesn't need to have knowledge of a specific diagnosis, but it does need to know and really grapple with understanding the substantial adverse effects and the long-term disadvantages that an employee may have. So, for example, if we've got an employer that says, I've self-diagnosed, that might not necessarily constitute knowledge. But if we've got an employee that says, well, this is my condition, this is the effect it's having on my day-to-day life, here are some examples of the effect it's having on my personal life, here are some examples of the effect that it's having on my work life. Some employees may provide statements from family and friends. Then when we've got that, it's likely that we're going to have knowledge that the employee is disabled. However, the case of Lingard versus Leading Learners Multi Academy, which is a 2023 decision, does provide some solace for employers here. So in this claim, we had an employee who herself had been unaware of the true nature of her disability at the relevant times. And this only really transpired over the course of proceedings during her ET claim, where expert evidence ultimately revealed a state of affairs to which everyone, the employee and the employer, had been completely oblivious. So in these circumstances, the employer said, okay, we see that she was disabled, but we didn't know that at the time, and indeed nor did the employee. So the tribunal held that the question, therefore, is always to look at the relevant time. Was there a disability, but also was there knowledge? And the tribunal did say that employers should not look at disability with the prism of hindsight, and ultimately concluded that it couldn't be said that the employer had turned a blind eye because they simply didn't have the requisite knowledge. So I think that just shows that there is scope to argue that knowledge isn't necessarily there, but employers should be sort of looking at all of the facts.
What should employers be on the lookout for in order to determine whether or not an employee might be disabled?
I think the best thing we could say to employers is to just be aware of potential disabilities and be aware of their employees. So employers should be looking at employee performance. They should be looking at the employees' one-to-ones. For example, is the employee struggling with their reading or their written communication? This might put an employer on notice that the employee has a learning disability such as dyslexia, for example. So it shouldn't be for the employer to wait for the employee to raise the matter of disability. Employers should be on the lookout and just seeing what they can do to help where they can see an employee is struggling, and that's likely going to be related to a disability.
And can we use occupational health in this context to determine whether or not an employee is disabled?
In short, yes and no. So occupational health reports are a really useful tool to get an independent opinion of whether the employee may or may not have a disability, whether something in the workplace is putting them at a substantial disadvantage, and it may well give you some suggestions to remedy any substantial disadvantage. But there has been a lot of case law around occupational health and the status of occupational health, and I think occupational health reports should come with a warning that they're not determinative as to the question of disability. Employers shouldn't rubber stamp their advice received by occupational health. The employer has to engage in a form of critical analysis on the guidance that it receives from occupational health. And the case of Gallup and Newport is a really good example of this. So in this claim, occupational health provided a report which was pretty bad. It gave an unreasoned opinion and a bare conclusion that the employee in this case wasn't disabled. And the tribunal in this case, in the first instance, found that the employer was perfectly entitled to rely on this. They'd referred the employee to occupational health. The view was unequivocal, and therefore the employer didn't have knowledge. But the appeal tribunal disagreed with that analysis. It allowed the appeal, and effectively held that where guidance is received from occupational health, employers mustn't forget that it's still on them to make the final judgment. They can't simply just rubber stamp an advisor's decision, and they should be engaging with that occupational health report practically and making sure that they really understand it.
And so you explained sort of kind of how easily it can go wrong, but how can the employer try and get the most out of the occupational health reports? What are some of the practical things they can do? And have we got any case examples that reflect that?
Yeah, absolutely. So I think what you get out of an occupational health report is very much dependent on what you put in. So it's all about asking the right questions. I think practical questions will provide real assistance to employers in getting a good and more robust report as to whether the criteria for disability is satisfied. So I think it's important that the employers engage critically in advance before going to occupational health. So I think to give a good example in terms of case law, we can very much contrast the case of Gallup with the case of Danielian versus Liberta UK. And in this case, the employer, in principle, was entitled to attach a great weight to occupational health's conclusion. So the employer in this case hadn't fallen into the same trap as the employer had in Gallup. It had conducted meetings with the claimant, the employee, to discuss their condition and discuss the effect of their condition. They'd got letters from the employee's GP. They'd got one occupational health report that they'd actually regarded as unsatisfactory, and they'd gone back and asked for reclarification. So this case was really far removed from a rubber stamping case. The employer had really engaged with the employee, it had engaged with an array of medical evidence, and it had actually said, well, I don't think the occupational health report is good enough. Let's go and reclarify some of these issues. This case is also quite interesting anecdotally because the court here also noted that the claimant, the employee, had adopted quite an uncooperative and confrontational stance in the context of obtaining medical evidence. So the tribunal here found that the employer had done all that they properly could.
It's really interesting, just reflecting on that one, that maybe the tribunal was influenced by the way that the employee had behaved. Because I think sometimes for employers, the difficulty can be that they perhaps don't quite get the occupational health report that they want. And of course, the temptation is perhaps to seek another one. But of course, that's a risky path. But if we then look at the sort of reasonable adjustments that might be made, obviously the EHRC code of practice sets out some of the things, and we've, I suppose, been dealing with those now for very many years. But looking then at sort of, again, some of the kind of case law on that, sort of recent sort of cases, what should the employer be thinking about?
Well, I think as you mentioned, the EHRC code is a really good starting point, and it gives a lot of examples as to reasonable adjustments that could be made. So one particular case that concerned a suggested adjustment from the code is Jandu against M&S. So Jandu against Marks and Spencers. And this case was all to do with a redundancy situation. So here we had an employee that had worked at Marks and Spencers for 22 years. They were a successful and perfectly capable employee, but in a redundancy scoring exercise, they were marked down quite considerably for reasons that were connected to their dyslexia. And the tribunal held that the employer should have discounted dyslexia-related difficulties in this scoring exercise. And it held that had the employer done that, it was likely that the employee wouldn't be selected. So I think that comes as a bit of a warning not to mechanistically apply criteria and really grapple with whether there are disadvantages to address.
It's a very interesting case, as you say. And presumably employers aren't bound only to consider the adjustments that are set out in the code. I mean, it's a non-exhaustive list.
Absolutely, yeah. And I think case law has actually really started to encourage employers to think outside the box. So we had a recent case of Hill versus Lloyds Bank. And in this case, the tribunal held that actually we can really get quite creative. with adjustments. So in this claim, the claimant, the employee, had some pretty big issues with two particular colleagues, and the employee was fearful of working with those colleagues and argued that they would be put at a substantial disadvantage by reason of their disability if they were required to work with these individuals. So the employee asked her employer, the respondent, to provide her with some undertakings. The first effectively providing that she wouldn't be required to work with or report to these two individuals. And the second was an undertaking that if the business did require her to do that, she would be offered a redundancy severance payment. And the Employment Appeal Tribunal held that this would be a reasonable adjustment. It said that there's no reason why the concept of reasonable steps and reasonable adjustments can't encompass undertakings. So I think it's actually very much open for employees and employers to kind of get creative and start thinking outside the box in terms of reasonable adjustments rather than just diligently sticking to the code.
They're a really tricky one. I mean, that last case, because I can absolutely see the point about the undertakings and not working with colleagues, even though that's problematic. Did feel a little bit like the employee was trying to have their cake and eat it and say, well, I want to work in this way. This is how I want you to create the environment for me. And then basically, if it doesn't work, I want you to pay me off. But obviously they found favour with the tribunal in that one. So if we're looking and determining the adjustments that are to be made, what's the kind of test? I mean, does the adjustment, what needs to be that the adjustment will definitely succeed in reducing or eliminating the disadvantage? How do we go about that?
So a key consideration would be the likely effectiveness of a proposed step. So if an employer has received advice, such as from occupational health or an employee's doctor, that if they do something, it's likely to solve the substantial disadvantage, then that's probably going to be quite compelling evidence to say that it may well solve the issue. It's also worth remembering that your organisation probably has some policies in place. So if an employer is saying that a request for reasonable adjustments isn't reasonable, but actually they've got a policy that says that this might be a reasonable adjustment, then obviously they're not going to find much favour with the tribunal. So I think it's very important to have a look at the organisation's policies, and then where we've got a reasonable adjustment listed within a policy, if it's been implemented for others in the past without success, if there's a sort of track record, then actually we may be able to turn around and say, well, we have done this before, and even though it's in the policy, it doesn't really work, then there's sort of documentary evidence. But there is then also an argument that actually different things will apply to different employees. So I think medical evidence as well as organisational policies are a really good place to start.
Okay, thank you. And you mentioned it might be worth implementing an adjustment where it's reasonable for an employer to do so. What would we need to look at to determine whether or not the adjustment is reasonable? Because you often get new employees saying, well, I want you to make these adjustments, and because it'll help me in these various ways. But there is obviously that reasonableness qualification. So how's that approached?
So assessing reasonableness will be very much a multifactorial exercise, but I think in my view, there are three main headings which employers should be considering in the context of making reasonable adjustments. So I think our first consideration would be the size and resources of the employer. For example, what's reasonable for a multinational conglomerate that's turning over millions each year is going to be radically different to what is reasonable and practicable for a small startup organisation that only has a handful of employees, is operating at a loss. And this leads us quite nicely into the second consideration, being cost. And this is really important to take into account, albeit not a complete defence in isolation. So cost is particularly important in terms of how that kind of tallies with the employee's role, with the turnover of the wider organisation, and whether or not external funding may be available, such as through organisations like Access to Work. So they're all things that an employer should be considering. But thirdly, employers are also going to want to take into account the effect that implementing an adjustment will have on the wider organisation. So an employer should be asking themselves, will the adjustment affect team structure? Will it affect client relationships? Will it affect client confidence in the organization? Would it affect service delivery? Will it result in other employees being burdened with a greater workload than they can realistically get done? So I think these are all sort of three poignant things, being the size of the organization, the cost of the adjustment, and the impact on the organization. But in any event, if an employer does want to say that an adjustment is not reasonable, they're going to need to have sound practical reasons to back this up at the time. Employers would therefore be well advised to keep a sound paper trail and ensure that any arguments as to why an adjustment isn't reasonable is supported by evidence. And a tribunal isn't going to like a baseless assertion that it's impractical if we get to the tribunal stage. So I think actually just having that evidence and having that thought process mapped out is a really important thing to do when assessing reasonableness of adjustments.
It's interesting, Lydia, just sort of saying about, impact on colleagues, impact on kind of service delivery. Certainly with colleagues, I know in the past there've been arguments about that could be, as it were, colleagues should expect, as it were, to help accommodate one of their colleagues who is disabled. Is there any recent case law to support this sort of multifactorial approach that you're referring to?
Yeah, absolutely. So one particularly prominent case is the case of Powell versus the University of Portsmouth. In this case, we had an employee, the claimant, who was a university lecturer, and he was suffering from blackouts. And he was off work, but he argued that he should be allowed to return with a support worker by way of a reasonable adjustment. And the tribunal disagreed with this. It firstly considered whether a support worker would actually alleviate the university's concerns, and it ultimately held that it wouldn't, because a support worker, of course, would not be able to prevent the blackouts. But the tribunal also really engaged with the nature of what actually procuring that support worker would look like, and whether that could be practically achieved given the intermittent nature of the work. And in this case, the claimant had also asked for a reasonable adjustment of allowing him to return to work by removing class teaching duties or lecturing duties from his role. And here the university were actually able to turn around and say to the tribunal, well, actually, we tried doing this for the claimant in the past, but ultimately we felt that this had compromised his recovery. So I think this further highlights that actually the best evidence that a reasonable adjustment isn't reasonable is, where possible to do so, just actually trying to implement that adjustment. And then if it doesn't work, what better evidence do you have to be able to say to a tribunal, well, we tried it and it didn't work, and therefore it wasn't a reasonable adjustment?
Lydia, thank you very much. You've given us a lot to think about, I think, today. So very grateful to you for joining. I hope that that podcast has been helpful. As I say, there'll be another one which sort of goes alongside it in relation to neurodivergent employees and some of the issues that arise, again, partly in the context of reasonable adjustments, but also managing them more generally. You'll be able to find that podcast, as usual, on Podbean, LinkedIn, and all your usual channels. Thank you all very much for joining.